the word political had been put in, and some, particularly small countries, tried to get that in and amend the definition. Was the response. Genocide is well established and we all know what it is. It's really dangerous coming up with a term like genocide, because the evil ones will narrow its meaning on you as a legal matter, and they did indeed. So in short, if you think that genocide circa 1971 included political grounds, then I think you're deluding yourself in terms of what international law apparently is. It's also the case that such as is as such in the treaty, which is very different, because the as such is meant to underscore the problem about and having the intent to destroy in whole or in part a national group as such. Now, of course, I think there are some serious proof problems, particularly in relation to individual Bangladeshis who will presumably be the defendants in this kind of case of proving it. You may be able to, and you may be able, if you go the whole or part route and emphasise killing the students or gender-based crimes, although gender as a matter of either crimes against humanity or war crimes really doesn't make it cleanly into international instruments until the Rome Statute of 1998, and it was controversial getting it in there. So at all events, I don't see how consistent with the principle of nullum crimen, no crime without a law, the principle of legality, the principle that you can't do something ex post facto, the whole theory about creating a new tribunal to deal with crimes which were not crimes under the 1860 Penal Code of Bangladesh, same as the Penal Code of Pakistan, and goes back to the old Indian Penal Code of 1860. These things were not crimes. If you're going to make them up, you've got to make them up on the theory at least that they are crimes under international law at the relevant time. All we're doing is setting up a tribunal, same as we did at Nuremberg or Tokyo, to give effect to them.
Counsel?
Yeah. The tribunal itself under this legislation is not military. It's just a tribunal that's appointed by the government. And the appeals go to the Bangladeshi Supreme Court, the regular courts. The crimes have to be committed by a member of an armed force or auxiliary. So there's that kind of military limitation, but that's the only military limitation. In terms of the crimes, it's true that, well, first of all, the legislation has no temporality. It doesn't say from this date. It goes both back and forward. It says whether before or after the commencement of this act. And what Roger Clark says is, of course, quite right. I mean, in international law, you can't prosecute someone for an act that was not an offense at the time. And part of the genocide, the political part of the genocide definition was not an offense at the time. At international law, you can say it became an offense in genocide, it became an offense in Bangladesh in 1973. So after 1973, even if it's not a crime in international law, it's an offense in Bangladesh. But in 1971, it wasn't an offense in Bangladesh, it wasn't an offense in international law, so it would be offensive to principles of justice to prosecute someone for political genocide for their responsibility for the Bangladeshi genocide. One has to distinguish between substantive law and procedure, because it is certainly true that you cannot prosecute someone for an act that was not an offense at the time of the act, but you can use current procedures. You're not stuck. Procedures are not stuck in time. You are not bound by historic procedures. I mean, you can, and the point that the panelist was making, that we should use, get the benefit of contemporary experience. I think we can get the benefit of contemporary experience in terms of procedure, even though we can't get it in terms of substantive law. I would also say that I mean, we don't need to change the law in order to get the benefit of procedure, because the law doesn't deal with procedure. We can just fill it in afterwards. I think the law could be cleaned up in terms of the definition of genocide, but I don't think we need to do that. As long as the prosecution is limited to acts that were offenses in international law at the time, there is respect for the law. And what I'm concerned about is just getting this thing going. And the more complicated we make the startup, the longer it is to get it started. I don't think that there's anything in the statute that necessarily is going to cause a problem. Actually, the thing that bothers me most about the statute is that it allows for the death penalty. And if I had one thing to change in the statute, I would remove that. But I would say even that is not necessarily a problem as long as the prosecutor doesn't ask for the death penalty and the court doesn't impose it. So the present law, although if we were redrafting it today, we can think of ways it could be drafted better, isn't itself an obstacle. It could be made to work consistent with current standards.
Professor Pati?
Maybe just a couple of words. Yeah, that would be absolutely correct in terms of procedure, that it can always be developed, and whatever the law is substantively, we have seen even the courts, the international courts, have already, their statutes are very meager, very sparse in procedural rules, and it's just that they are guided to establish their own rules of procedure and evidence, which, by the way, have been changed and amended in the process of prosecution, investigation and prosecution for so many times. And something else that I would have liked to mention, maybe see differently, and maybe that's why I even think of having a different tribunal maybe is better than just domestic one, is the fact that, if I got it correctly, that looking at the defendants, what we are looking to prosecute are only the Bangladeshi nationals. And I do not know how fair that can really be. Yes, I heard one of the individuals that was interviewed in the documentary that was saying it's quite frustrating, and I'm paraphrasing, it's quite frustrating to see that so many of the collaborators, people that actually had a finger in the pie, they had their dirty hands in blood, they are benefiting in the situation and in the country, and many of the victims and survivors and so on are really not. They are abandoned and forgotten. And that is important, particularly when you see it in the context of a country. And I do come from a former communist country myself. And if there is something that if I have had the power to do during the early 1990s would have been to bring to justice all of those that really persecuted and killed about a third of the population of my country. Although this was internally. But if you will, in a way, it was internally within Pakistan as well. No matter that unfairly it was during the partition put together in one way, and that's why ultimately one of the best achievements is the independence. But I also think it's very important to bring to justice all those individuals that are beyond the Bangladeshi borders. Because probably if we talk about individuals that are in leadership, that were in leadership positions, the real masterminds, the real instigators, and so on, they are probably not even in Bangladesh. And forgive me if I'm wrong, because obviously I do not know the situation anywhere near as good and as well as you do. But I wouldn't be surprised if some of them were here in the United States, and lots of them in Pakistan, or in any other country for that matter. And while we can always search for other avenues of justice as well, and in the United States, for that matter, even civil liability is also an issue through alien tort claims there. But I think it is important to really expand beyond just the Bangladeshi individuals, because I don't know how many of these defendants are we talking about, how many we have been able already to spot, what's the list that we have, how long do we think we'll be able to go, what materials and evidence do we have, and how even procuring them. when you have an international community involved and more than one country involved,